All right, Mr. Page, this is 242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Zick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan, appearing today sui juris. I'm here under special appearance and under duress to address this matter.
Welcome back to the channel. Today we're diving into not one, but two sovereign citizen cases. And trust me, both are wild rides. First up, we've got Mr. Zachary Page, who walks into Judge Shackelford's courtroom armed with a classic sovereign citizen script. But here's the kicker. He's literally reading it off a piece of paper, mispronouncing the Latin phrases, and stumbling like it's open mic night. This isn't legal strategy. This is improv gone wrong. Then, as if that wasn't enough, we pivot to our repeat guest, Mr. Michael Valentine, aka the self-proclaimed American National. If the first case is messy, the second is downright chaotic. Valentine has been juggling pre-trial violations, drug test failures, and bail disputes, all while insisting the court doesn't even have authority over him. Spoiler, the judge is not buying it.
I'm the beneficiary of the trust established by the U.S. Constitution and the Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat the last part, please?
You could stand mute. That means you don't say anything and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to this.
When Mr. Page insists on representing himself, the judge wastes no time reminding him. Self-representation isn't a free pass. You don't get special rules. You don't get leeway. You're held to the exact same standards as a licensed attorney. And here's the reality. That's a recipe for disaster. Sovereign citizens love the idea of fighting the system, but in practice, it's like stepping into a boxing ring with zero training. The judge even shows him the Michigan Court Rules, a massive book covering evidence, procedure, and trial conduct. Spoiler alert, Page hasn't studied a page of it. But once you waive your right to an attorney, you're all in. This is where it usually unravels.
Sorry, I have to go over a few things with you to make sure you understand them, okay? You're
Yeah.
charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree, I'm asking if you understand. And is that a yes?
Yeah, I understand.
And here comes the sovereign citizen monologue. Mr. Page starts rattling off his status as a living man, declaring his appearance through special jurist, and citing constitutional trusts, as though the U.S. government is secretly a giant banking scam. Now, for the uninitiated, this is classic sovereign citizen playbook, mixing legal jargon with misunderstood constitutional principles. The problem? Judges have heard this 1,000 times. Notice how Judge Shackelford immediately shuts it down. You can submit it in writing. I've heard it all before. Translation: this isn't new, and it won't work. But sovereign citizens don't back down. They double down. And that's exactly what keeps these exchanges so fascinating.
Valentine. Unmute, join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, oh, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted that the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh,
I can hear you. I can.
okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were.
At this point, Page pleads not guilty. But here's what stands out. Unlike veteran sovereign citizens, who sometimes refuse to plead altogether, Page complies without realizing he's undercutting his own script. Sovereign citizens often pride themselves on never entering into contract with the court, but Page just walked right in. And you can tell by the way he hesitates and asks the judge to repeat herself that this is his first rodeo. He's not confident, he's not polished, and the judge knows it. This isn't rebellion. It's amateur hour, and the courtroom dynamic shows it.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything.
We got
waiting for
everything.
Tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. It's my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
even my bail, they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
So, all right. So you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case, but they're two separate cases now.
All right.
Enter Michael Valentine, or as he prefers, American National Valentine. This case ramps up the drama. Here's a guy who already had bail reduced once, only to rack up multiple drug test violations within weeks. Cocaine, THC, diluted samples. It's all on record. Yet, he insists the state is being prejudiced against him. But here's the kicker. Bail isn't a permanent guarantee. Judges adjust it based on compliance, risk, and behavior. When Valentine claims he should be released on personal recognizance, basically no bail, the judge isn't amused. And honestly, why would she be? He's already proven he can't follow conditions. This is courtroom reality colliding with sovereign citizen fantasy.
All right. I guess I don't agree with you. There was a request to October 28th to change the release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount to, because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing on, I'm gonna set this, it's going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. So we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending in the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it
Nature of
under
the cause.
admiralty jurisdiction or common law jurisdiction?
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a
That's what I'm
common
telling
law?
you.
Is it
Nope,
under
it's under
common law
RCW
or admiralty?
4661. It's under Washington
So-
state law.
Don't you
Washington
have the
state-
duty to make the nature and cause clear to me, ma'am?
I
Do I
have,
not have a right to know the nature of the cause?
yeah.
nature and
and I
cause?